Did you know that, at one time, neighborhoods could use private contracts to block families from buying homes based on race? This is Courtroom Explained, where we calmly examine how Supreme Court decisions shape constitutional protections. This content is for educational purposes only and not legal advice. Today's case is Shelley versus Kraemer, a landmark decision on housing discrimination and the Equal Protection Clause. According to court records, J.D. Shelley, an African-American homebuyer, purchased a house in Street Louis that was subject to a racially restrictive covenant, a private agreement barring sales to non-white buyers. These covenants were private contracts, not government laws, and supporters argued that private parties could freely enter into them. Neighbors sued to enforce the covenant in state court, raising the question of whether judicial enforcement of such agreements counted as state action under the 14th Amendment. The Supreme Court examined whether state court enforcement of racially restrictive covenants violated the Equal Protection Clause. The court unanimously held that while private individuals may make such agreements, state courts cannot enforce them, as judicial enforcement amounts to state action and must comply with the Constitution. The legal lesson from Shelley versus Kraemer is that constitutional protections apply not only to laws, but also to how courts enforce private agreements when state power is used to uphold discrimination. Equal protection principles are triggered. How should courts decide when private conduct becomes state action? Share your thoughts in the comments. And if you value clear, neutral explanations of landmark cases, consider subscribing to Courtroom Explained.